In 2006 Devil Wears Prada, Miranda Priestly delivers what is perhaps the most elegant dismantling of fashion ignorance ever committed to film.
That blue represents millions of dollars and countless jobs. And it's sort of comical how you think that you've made a choice that exempts you from the fashion industry when in fact you're wearing a sweater that was selected for you by the people in this room. From a pile of stuff.
She wasn't just teaching her assistant what color her lumpy blue sweater was, she was delivering a masterclass on cerulean blue. She was talking about color. And she's right, color does represent millions of dollars in countless jobs. But the question we should be asking here is, can somebody own color? Fashion law is not just about handbags and couture. It's about identity, exclusivity, and the weaponization of perception, and nowhere is this more true than in the battle over color. When a consumer sees a flash of red on the bottom of a stiletto heel, they do not need to look for a label, nor they need to look for a logo, because they know it. That red signals not only luxury, but they signal Christian Louboutins. When somebody spots that particular robin's egg blue on a small box tied with a white ribbon, they know it's Tiffany & Co. Color at this level is no longer just an aesthetic, it is a brand asset, and law, slowly and painstakingly, case by contested case, has to decide when does a color stop belonging to the world and start belonging to a brand. Here is what the law says. Number 1, you cannot copyright a color. Copyright law protects original creative expression. It can be a painting, a poem, a pattern, but a singular color is too basic and too universal to be protected under copyright law. A color is a wavelength of light and it belongs to everyone. Secondly, you can, under certain conditions, trademark a color. The United States Supreme Court confirmed in the Qualitics Co. versus Jacobson Products 1995 that a color can function as a trademark provided that it has acquired what lawyers call a secondary meaning. It basically just means the public has come to associate that specific color with a specific product from a specific source. Examples being the Tiffany blue, the Cadbury purple, the UPS brown, or the Post-it note yellow. But there are two critical things: the distinctiveness requirement and the non-functionality doctrine. The color must have a secondary meaning. It has to be so thoroughly associated with the product that the consumers would be confused if the competitors use that color. And the non-functional doctrine says that a color cannot be trademarked if it serves any functional purpose. It cannot be monopolized. Yellow for safety equipment, red for stop signs, green for lawn products. These functional colors would give the brand an unfair advantage and therefore cannot be trademarked. It is important to note that secondary meaning takes time. You have to be in the market for years and years consistently for your consumer to associate a color with your brand. A definitive landmark case here would be the 2012 Christian Louboutin versus, pardon my French, Yves Saint Laurent. In 2011, YSL released a collection of fully monochromatic shoes, including an all-red shoe. Red upper, red sole, and red heels. Louboutin dragged them to court, and YSL fought back with the argument that you cannot trademark a color in the fashion industry. Why? Because it serves a functional purpose in the aesthetic sense. To allow one designer to monopolize on red would be to impoverish every other designer's palette. The US Second Circuit Court of Appeals delivered a ruling where Louboutins won and lost simultaneously. The court upheld that the red sole mark was a valid trademark, but only when it contrasted with the rest of the shoe. The black and red contrast protected. But a red sole on an all-red shoe, that is not protected because that belongs to no one. In this context, the sole design is not a brand identifier, it is just a part of the monochromatic design. YSL could keep selling their red shoes and Christian Louboutin could keep their iconic red sole design. So here, the law isn't protecting the color in itself, it is protecting the meaning that the color carries. So the next time you see a red sole flash across the room, just know that somebody went to court for that.